each one of those counts beyond a reasonable doubt. Do you understand?
I do.
If the state is able to prove those counts beyond a reasonable doubt, and if they are able to approve the habitual offender enhancement paragraphs, your range of punishments for counts 1, counts 2, counts 3, counts 4.
A defendant walks into Judge Boyd's courtroom and says he wants to represent himself. But this is not a small case. The charges include aggravated robbery, aggravated assault with a deadly weapon, and unlawful possession of a firearm by a felon. Judge Boyd has to make sure he understands exactly what he is giving up, and exactly what he could be facing if this trial goes wrong.
For the defense?
Felon McCray on behalf of Mr. Ross, who's standing in front of me.
All right, and Mr. Porter?
Yes, Your Honor.
And you're on this case as well, is that correct?
That's correct.
All right. And you're-
Objection, Your Honor.
Let me finish. Here's the thing. Let me finish. All right. And also, Mr. Porter, you're a second chair?
Yes, Your Honor.
All right. So, Mr. Ross, it's the court's understanding that you wish to proceed pro se, is that correct?
It is correct.
All right, you want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Do.
All right, you can lower your hand, state your name for the record.
James Ross,
All right, how old are you?
43,
And what is your highest level of education that you've completed?
second year in college.
All right, are you able to read, write, and understand English?
Yes.
Are you under the influence of any type of alcohol, drugs, or medication?
No.
Have you ever been treated for mental illness or any type of cognitive impairment?
No.
Do you understand why you're here today?
Do.
And why are you here today?
Being accused of aggravated robbery and intend to defend myself against these charges.
All right, do you understand that in felony cases, you have an absolute right to have an attorney?
I do.
And do you understand if you cannot afford an attorney will be appointed to you?
Understand that.
And you understand the attorneys that have been appointed to you are Leland McCray and Robert Porter as second chair. Do you understand?
I do understand that.
And do you understand that the appointed counsels are trained in the practice of felony criminal law and trial practice?
Hard for me to tell.
Now, here's the thing. I'm asking you questions, and your answers to my questions are going to be appropriate. We're not going to do this thing where we're saying disparaging things against each other. Do you understand?
Yeah.
So you understand that your attorneys are trained in felony criminal law.
Do.
And you understand that they're trained in trial practice.
Do.
And do you understand in order to be appointed to represent you, they have to have been approved for appointment levels at the level of first-degree felonies?
I do understand.
And have you discussed with your attorneys your request to represent yourself? Have you discussed with both attorneys that you wish to represent yourself?
I have, but before we get to that point, I gave him ample opportunity for, produce any type of defense for these charges, and he's done nothing. He's not.
All right, just a moment. Okay, so I'm going to continue asking my questions and just, give me an answer. So it's my understanding, and we're back on the record, it's my understanding that you are asking to represent yourself. Is that correct?
That's correct.
Okay. Did you inform your attorneys that you wish to represent yourself? Okay. Now, do you understand that if you wish to represent yourself, there has to be a written voluntary waiver of the right to counsel? Did you understand?
I do.
All right. And that must be in writing and on the record. Do you understand?
I do.
Has anyone threatened you, coerced you, or promised you anything that would cause you to waive your right to have counsel?
No, but I have a question.
Yes.
So would Mr. Porter be still sitting in my second chair with Mr. McCray being relieved?
Mr. McCray is not being relieved. Mr. McCray and Mr. Porter are co-counsels on this case.
I don't want him on my case, Your Honor. He's moved arbitrarily to my best interest.
Mhm.
He's not filed a single pretrial motion,
Mhm.
which relieves me of any type of pretrial maneuvering ability.
Mhm.
I can't get a fair trial with anything he's done. He's refused to show me my discovery.
Mhm.
He's secreting evidence from me. I don't even know the case,
Mhm.
the state's case in chief about any of it at all. And it's been filed. And he's refusing to cooperate with me on these terms.
Mhm.
Continues to embellish these stories as if I'm being aggressive to him in some way, but not producing anything in lines of the things that I've asked for.
So are you saying you haven't seen a police report?
I have not.
All right. I'm going to continue to go over this. And then if you're saying you haven't seen a police report, I'm sure they'll show you that police
It's not
report
on
right
the
now.
Police report.
No.
it's-
Here's what we're going to do. We're going to answer the questions that I'm asking of you. Do you understand? All right. So back to my question. You've informed the council that you wish to represent yourself. Is that correct?
That's correct.
Now, do you understand that per the indictment, these are, of course, felony charges? Do you understand?
I do.
Do you understand if the state is able to prove up their enhancements? Well, I'm sorry, let me rephrase. For each one of these cases that are in the indictment, the state has to prove each one of those counts beyond a reasonable doubt. Do you understand?
I do.
If the state is able to prove those counts beyond a reasonable doubt, and if they're able to approve the habitual offender enhancement paragraphs, your range of punishments for counts 1, counts 2, counts 3, counts 4 are 25 years to life in prison and up to a $10,000 fine. Do you understand?
I understand.
And do you understand that if they are able to prove the enhancements, there is no eligibility for probation from a jury? Do you understand?
I do.
Have you received and reviewed a copy of the indictment?
No, I have not.
All right. Mr. Ross, I'm going to give you a copy of your indictment.
And it says, according to Article 25.01, that the district clerk is supposed to.
Well, hand that back to me.
Thank you.
Yaya, if you will please give him a copy of his indictment.
Certified
And
copy
let
of the
me-
original.
And excuse me, and let me explain something to you. When you have attorney that is representing you,
He's not.
the attorney will receive that, and the attorney will hand it to you, and that is through the district clerk. But we'll make sure you have that today. All right, do you understand what you're being charged with in the indictment?
Do understand it.
All right,
But,
do you understand the
yeah.
elements the state must prove?
I do, and I object to the indictment.
All right, I'm sorry?
I object to the indictment.
All right. But do you understand do you understand all of the elements that the state has to prove?
I do.
Do you understand the full range of punishment with regards to each charge?
It's what you just explained to me.
My question to you is, do you understand the full range of punishment?
25 months.
So for the record, I'm taking that to mean that the defendant does understand. And do you understand you have a right to a jury trial? And if you choose not to have a jury trial, the state will have to agree to a waiver of a jury trial. Do you understand?
I do.
Do you understand that there will be 12 jurors that will be sitting to hear the evidence in this case? And those 12 jurors must come to a unanimous decision if they're able to. Did you understand?
I do.
Do you understand that during jury selection, there are available to you strikes and peremptory challenges?
I do. Or die.
All right. Yes. Do you understand if you're not a U.S. citizen, that you will be deported, denied naturalization, and reentry? Do you understand?
I do.
All right, then the court will allow the defendant to represent himself. And I'm sorry, after hearing all of the court's questions and answering them, do you still wish to waive your right to counsel?
As in, do I?
Do you still wish to proceed do you still wish to proceed in representing yourself?
I do.
All right, then the court will allow you to proceed to represent yourself. There will be standby counsel. You'll need to sign the waiver And once you sign the waiver, we will bring the jury in. We'll start with jury selection. Do I have parties re-announce?
Brandon Brady from the state.
James Ross. For the
Right.
defense.
Well, we've had conversations with Mr. Ross.
No, I need the people to announce. So your standby counsel and your. if
Call
you
reporter,
announce-
standby counsel.
Felon McCraven.
Standby.
Standby, I'm sorry, standby B counsel, two B counsel, on standby.
Standby.
With that being said, Your Honor, we had a conversation with Mr. Ross. Myself and co-counsel are very familiar with picking jury. We understand how to pick the jury package, the questions to ask. Mr. Ross, if I'm not mistaken, just gonna let us do the jury pick form. We're just gonna take over the case in chief, defend himself, ask the questions, present whatever evidence he wants to present. Is that a fair representation, Mr. Ross?
That is minus one important key part. I have not had a compulsory process where I can add evidence in that I wanted to put.
My question for you is, do you want these attorneys to complete the jury selection? Or are you completing jury selection? That's my only question right now.
They are with my input.
So are you asking that for this portion of the trial, that you proceed with the two standby counsel in completing voir dire? Is that what you're saying?
It is with my participation, Your Honor.
Defendants always participate. So, but my question is, are you asking that the two pro se counsel complete jury selection? That's either a yes or a no.
It's a yes.
All right, thank you. You may be seated. All right, let's bring the jurors in. So you are here for jury selection. And I appreciate y'all waiting in the hallway. I want you to know that your wait in the hallway was not in any way related to this case. It's just that sometimes we have other cases that are on the docket and we need to take care of them before we move towards this. So you are in the 187th District Court. You're on the 4th floor and I'm Judge Boyd. What floor are we on? What's the court number? Who's the judge? All right, and you all are asking, why is she asking us this? We've been standing in the hallway. We know where we're supposed to be. The reason why I ask that of jurors is based upon my experience, because whenever we take a break and whenever anyone requests a break, everyone has to leave the courtroom. You can't say, well, I'll just wait here because I don't need a break. Everyone leaves. And it never fails that when people leave, people get lost. And we had somebody trying to get selected on another jury and they say, I looked up and everybody was gone. So if we ever take a break and you're lost, if you remember the 187th or if you remember Boyd, people will be able to direct you because this is the only 187 district court in all of Texas. And I'm the only Boyd at the courthouse. So now that I've introduced myself, to my left is the court reporter. The court reporter takes down everything that everyone is saying. Please speak at the tone that I'm speaking at so that she can hear. Now, this is what I want everyone to do. You have cards. You may be sitting on them. Please raise those cards. And do not lower those cards until I tell you to lower the cards. Whenever you have something you want to say, whenever somebody asks you a question and you want to respond to those questions, raise that card. Now, I'm going to ask you to do something for me now. Jurors 1 through 21, lower your cards. See, 75 was lowering. Only 1 through 21. If your hand is still raised, what that means is whenever you answer a question, I'm going to need you to stand to answer it so that the court reporter can hear. Is everybody able to do that? All right, I'm going to tell you right now, every jury that we've had, and we're usually in jury trial every week, every last one of those jurors has said, yes, we can do that. And every last jury has failed to do that. But I'm going to tell you what I told the last jury. I have faith that you will do that. If you see someone not doing it, just tap them on the shoulder, all right? You can lower your cards. To my left, these are interns, they're students. So they're here to observe and to learn. You will see people coming through this door. They're coming through that door for documents for me to sign. It has absolutely nothing to do with this case. When you see people coming through that door, they're coming through that door because they didn't read the sign that says, please do not come through this door. We're in the middle of jury selection. So with that being said, I'm going to have the parties introduce themselves for the state.
Good afternoon, everybody. I'm Brandon Craig, state of Texas.
My name's Lauren Espinoza and I also represent the state of Texas.
Defense.
I'm Leland McCray on behalf of Mr. James Ross.
Robert Porter. Good afternoon, ladies and gentlemen.
I'm James Ross, the defendant.
Right, everyone, please be seated. Now, what I'm going to tell you all is that everyone who is charged with a criminal case is entitled to be represented by defense attorneys. Sometimes you will have people who will say, I want to represent myself. In which case, when that happens, there's usually standby counsel that is still there to provide any advice if someone who's accused of a crime wants advice. Does everyone understand?
Yes.
So in the United States, people who are charged with criminal cases are entitled to attorneys. In this case, Mr. Ross has made the decision that he wants these two attorneys to complete the jury selection, which we call voir dire. And then after that, he may decide that he wants to proceed representing himself. Does everyone understand?
Yes.
Is there anyone here who's going to hold it against Mr. Ross if Mr. Ross decides that he wants to represent himself? Okay. Now, everyone who has a felony criminal case charge, they are brought to court by what's called an indictment. And an indictment is just a document, and that document is to tell someone what they're being charged with so they'll know. It would be a sad state of affairs if you're charged with an offense and everybody wants to keep it a secret and you don't know about it until you hear witnesses come in. So raise your card if you have ever had a traffic ticket. All right, now I will say something about this group. This is some of the worst drivers we've had. All right, you can lower your car. So I've had a traffic ticket before. It was when I was 19. So here I am, 21 years old. And it's just, you shouldn't laugh that hard. You should say, oh my gosh, she's super intelligent. So what ended up happening when I received my traffic ticket is you got pulled over. And that was back in the day where they just had paper with carbon paper and they write down what they're saying you did and they hand you a ticket. That when you are pulled over, and let's say hypothetically you're pulled over, and let's say they say you ran a stop sign. So the officer pulls you over, and I think now they have some kind of electronic device, and they print it off to you, they give it to you. When you accept that, you're not saying, yes, officer, you're correct, I ran a stop sign. That piece of paper is to let you know the officer is saying you ran a stop sign. This is where you need to go to answer for the officer's allegation, and usually that's on Frio Street. So an indictment is the same thing. An indictment is saying, this is what you're being accused of, and if you want a jury trial, this is where you need to be. But it is not evidence of guilt. It is not evidence of anything. It's just a piece of paper to give someone who's accused notice of what they're being accused of. Does everyone understand? So with an indictment, you're not allowed to hold that against anyone when they are here by an indictment. You are not allowed to consider that as any evidence whatsoever. Does everyone understand?
Yes.
Just think of the indictment as a document for someone who's accused. It's for them to review, for them to know what they're being accused of, but it's not to be considered by you in any way whatsoever. Does everyone understand?
Yes.
Is there anyone here who's going to hold it against Mr. Ross because he's here under indictment? Is there anyone here who's going to consider this indictment other than just a piece of paper to give him notice? All right, the next thing I want to talk to you about is hypotheticals, right? The state nor the defense, they're not allowed to tell you what they think the facts are in this case. You will only learn what the people think the facts are in this case if you're selected to be on the jury trial and evidence is presented. So when the state speaks to you, when the defense speaks to you, they're speaking to you in hypotheticals. So don't be like Mrs. Kravitz and Bewitched and say, oh, that's what this about. No, It's not. You just listen to their hypotheticals. So you watch Bewitched. Other people, I guess, they never watched it. All right. So the other thing I want to talk to you about is the charge in this case. So there are 4 counts. Count 1 is aggravated robbery. Count 2 is aggravated assault with a deadly weapon. Count 3 is aggravated assault with a deadly weapon. And count 4 is unlawful possession of a firearm by a felon. Now, in Texas, usually, and in this case, one of the ranges of punishment is always up to a $10,000 fine. That $10,000 fine, nobody knows where it goes really, but that's a range to consider, $10,000 fine. And then you have ranges of punishment. Sometimes your ranges of punishment in some cases may be 5 to 99 years or life in prison, maybe 2 to 20 years or life 2 to 20 years and up to a $10,000 fine, or 2 to 10 years and up to a $10,000 fine. As you can see, those are wide ranges of punishment. So for any first degree felonies, the range of punishment can be anywhere from 5 to 99 years or life. What does that really mean? That means that a person could be sentenced, if found guilty, 5, 6, 7, 8, 9, 10, 20, 30, 40, all the way up to life. Second degree felonies, the range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. What does that mean? Somebody could be sentenced to 2, 3, 4, 5, 6, all the way up to 20. Third degree felonies, 2 to 10 years. What does that mean? Somebody could be sentenced from 2, 3, 4, 5, 6, all the way up to 10, and all of it up to a $10,000 fine. Does everyone understand?
Yes.
Now, in some cases, depending on if someone is found guilty and what is or is not proven, a person could be eligible for probation. It just really depends. Does everyone understand?
Yes.
And in some cases, the ranges of punishment may end up being at a minimum of 25 years in prison, all the way up to life. So that's 25, 26, all the way up to life. Does everyone understand?
Yes.
Now, when we talk about ranges of punishment, people will say, well, I can't give this or I can't give this in a specific case. But it's not whether or not you can give a specific number if you were to find somebody guilty. The question is, can you internalize that that's the law? Is there anyone who will not be able to follow the law, that those are the ranges, potential ranges of punishment? Then the question becomes, if you were to find somebody guilty, would you be able to take your knowledge of the range of punishment and any evidence that's presented to you and come to a decision on punishment? Does everyone understand?
Yes.
Is there anyone here who would not be able to do that? Now, the next thing I want to talk to you about is certain rights that people who are accused have. One is the right to remain silent. What does that really mean? That means that you don't have to testify if you don't want to testify. I've been a defense attorney, I've been a prosecutor. And let me just tell you, as a defense attorney, sometimes I would have clients and I would tell my client, you're nervous with me and I'm on your side. It's not a good thing that you can testify, right? Because sometimes people will say, oh, I know that person's not telling the truth because they can't look me in the eye or because they're sweating, these type of things. And then sometimes I would have clients, I would say the state hasn't proven their case. There's no reason for you to testify. And then sometimes I would have clients, they would have a speech impediment and they just were like, I really can't do it. So there are a host of reasons why people would exercise their right not to testify. Now, what I've discovered when I talk to the public, they will always say, well, if that was me, I want to tell my story. I hear that a lot. And I always chuckle inside because I'm like, that's not you. And that's not you with maybe an attorney who's advising you. Sometimes people don't consider attorneys in the same realm as doctors. But when you think of medical doctors give you advice, and usually you follow the medical doctor's advice. Well, it's the same thing with attorneys. They will give their clients advice, and sometimes they will follow the advice, sometimes they will not. But the key to the right to remain silent is If Mr. Ross decides not to testify, is there anyone here who's going to hold that against him?
No.
Okay. Now, the next thing I want to talk to you is everyone who's charged with an offense is presumed to be innocent. What does that mean? If you're accused of a crime, you're presumed to be innocent. And guess what? The state has to prove your guilt beyond a reasonable doubt. They have to prove each and every element beyond a reasonable doubt. So in all cases in Bexar County, if you're charged with a case and you're being tried in Bexar County, guess what? The state has to prove that whatever they're saying happened in Bexar County. They have to prove an on or about date. So they have to prove every single element beyond a reasonable doubt. And if they fail to prove their case beyond a reasonable doubt, it doesn't matter if they fail to prove that it happened in Bexar County. If they fail to prove the on or about date, what should your verdict be? All right, so what should your verdict be? All right, so with the presumption of innocence, that basically cloaks the defendant, right? If the state is not able to prove their case beyond a reasonable doubt, then your answer should be not guilty. So right now, how much evidence have you heard about this case? So if you were asked to give your verdict at this point in time, what should it be? Okay. Now, I want to talk to you about fairness. What does fairness mean? Because people will say, are you biased? Can you be fair? This is what that means. Let's say you're coming down for jury duty and your plans are, you know what, I'm going to map it out because I know there's construction. I'm going to drive the night before. So you drive the night before so you can put in your plans. You get up super early the next morning and you come downstairs and your car is on cinder blocks. Somebody's taken your tires, they've broken into your vehicle, but you want to do your civic duty. So you say, you know what, I am still coming down to do my duty. And when you come down, you come either on Via or by Lyft or your next door neighbor brings you and you're standing in line outside waiting to see what case you're going to get. And it's a criminal case. And when you come in, you're sitting down and a judge tells you, all right, we're here on a burglary of a vehicle. Attorneys will usually ask you at that point, you can't really be fair because your vehicle was just burglarized. That is really not the appropriate question. This is the appropriate question. Your vehicle was burglarized. You have been selected to be on a jury where somebody is accused of burglary of a vehicle. Are you going to say, you know what, my vehicle was burglarized. This person is accused of burglary of a vehicle. I really don't care. This person needs to be found guilty. I don't care what's presented. That's what it means by fairness, because all of us come with backgrounds. All of us come with maybe something that happened bad in our life. As I tell everybody, how many people, raise your card if you were born yesterday and you slept all last night. If you don't fit that category, that means that you have maybe have had some good things happen to you and some bad things happen to you. So in this case, the question is, will you, if you're selected to be on this jury, will you be able to listen to whatever evidence is presented to you and make a decision based upon the evidence that you're here, if you can come to a decision? Does everyone understand my question?
Yes.
Is there anyone who would be unable to do that? Okay. Now, the next thing I want to talk to you about, and I've already talked to you about ranges of punishment, but in Texas, there are 2 phases to a jury trial. People like to call it the innocence phase as phase 1, but it's really not. The first phase of a jury trial is, did the state prove their case or not? If the state didn't prove their case, then somebody's not guilty and you don't have a phase 2. If the state did prove their case, then the next phase is what's called the punishment phase. And briefly, could I have attorney's approach? All right, so if somebody is found guilty, then you have the next phase, which is called the punishment phase. In Texas, before a jury is selected, before we do this voir dire, anyone who's accused of a criminal offense must make a decision on if they were found guilty, would they go to the jury for punishment or to the court for punishment. And in this case, if they were going to the court for the punishment, it would be me, or they can make the decision to go to the jury for punishment, which would be whoever would be on this panel. So in this case, Mr. Ross has decided if he were found guilty, the jury would decide his punishment. Does everyone understand? And it's the law that he needs to make that decision before jury selection. Now, by making that decision, that doesn't mean he's saying he's guilty. It's just the law that he needs to make that decision. Is there anyone who's going to hold it against him for deciding that if he were found guilty, the jury is to decide punishment? And I've already talked to you about the ranges of punishment. Next, I love languages. I think languages are beautiful. When I was in undergrad, grad school, and law school, there were some people who were from different countries. They spoke no less than 6 languages. Me, I'm not supposed to be in Texas. I'm originally from Louisiana. You can tell when I have to say words like oil and soul. I was not supposed to be here. I was supposed to be retired at 22. I'm supposed to be living in Paris. That's why I took French. When my friend Tanya was like, Stephanie, let's take Spanish together. And I'm like, I will never use it. Why should I take it? So I'm slowly learning it. But raise your card if English is not your first language. And just please keep your card raised until I call your number. So we have 12, 13, 20, 23, 31, 35, 43, 44, 47, 56, 70, and 75. And number 7, you have yours up as well? All right, 7. What is your first language?
Spanish.
Have you been able to understand everything?
Yes, ma'am.
Thank you. Number 12, first language.
Spanish.
Have you been able to understand everything?
Today, yes.
All right, thank you. Number 13.
Spanish.
Have you been able to understand everything? All right. Number 20. First language. Have you been able to understand everything? All right, so everyone, I'm gonna need you to keep your voice up. Remember, Cindy has to take everything down. So you say yes? All right, thank you. 23. Have you been able to understand everything?
Yes.
Thank you. 31.
Yes. Spanish.
Okay, I still have faith in you guys. You can save us. All right, 31 in Spanish. Have you been able to understand everything? All right, 35.
Spanish.
Able to understand everything?
Yeah.
43.
Spanish.
And you've been able to understand everything? Thank you. 44. And have you been able to understand everything? All right, when you say not really, what do you mean? All right, so did you go to school here? All right, so how long have you been here? All right, thank you. 47. Have you been able to understand everything? Thank you. 56. Have you been able to understand everything? All right, I can pretty much say hurry up in every language, but I haven't learned it in Japanese. How do you say hurry up? It's soye. All right, thank you. I'm going to add that to my repertoire. Number 70. Yes.
Spanish.
Have you been able to understand everything?
It's mostly hearing.
Hearing.
Yeah.
All right. If there's any time someone can't hear, if you'll just point to your ear, we'll know that that's a sign that you can't hear, and we'll have everyone speak up. Thank you. 75.
Portuguese.
Have you been able to understand everything?
Yes, ma'am.
And how do you say hurry up in Portuguese? Thank you. All right, the next thing I'm going to talk to you is about travel arrangements and time constraints. It's expected that this trial will be concluded before Friday or at the latest by Friday. And that's Friday this week. And when we will start with testimony, that will be tomorrow at 1 p.m. So is there anyone who has any type of time constraints, travel arrangements, you have a ticket, it's non-refundable or anything of that nature? Anything involving time constraints, anyone, speak now or forever hold your peace. All right. When I call your number, lower your card. 1, 2, 6, 10, 11, 14.
Excuse me, it's 9.
Oh, 9, not 6, but number 9.
Oh.
Oh, thank you. You turn it upside down. Don't do that on doors. That's how bills get delivered to the wrong place. So 1, 2, 9, 10, 11, 14, 15, 21, 37, 41, 42, 45, 48, 50, 52, 55, and 57. Juror number 1, what's your time constraint?
I have a medical practice. I have patients scheduled the rest of the week.
All right, thank you. Number 2,
Yes, ma'am. My wife works shift work at the hospital and I have young kids,
and what are their ages?
12 and 7.
And are they in school?
They are.
And what's drop off and pickup?
Drop off is at 7:30, oh, well, 7:10 and 7:50. My wife has to be at the hospital at 5 in the morning. We don't have buses.
And pickup?
Pickup is at 3 and 3:55.
All right, thank you. Number 9,
One of the grandparents in my family is in the ICU and is very near death. I actually drove here from Killeen last night to be here this morning.
all right, do you, okay, all right, thank you. Number 10,
I have numerous cases the rest of the week.
thank you. I say that so everyone will know, I do know that specific juror. He's an attorney. All attorneys usually know each other. And are those CPS cases?
Yes,
Any CPS cases that are scheduled for trial?
I'll look through.
All right, we'll come back to you, but just let us know if there are any CPS trial cases scheduled from now till Friday. Number 11,
My son and my daughter-in-law are both physicians, so they work like very long hours.
and what are the grandchildren's ages?
8 years.
And who's with them now?
Well, I had to postpone this a few months ago, so she could ask for a day off today.
All right, thank you. Number 14,
Yes, my wife is going on a work trip tomorrow. She's up for the rest of the week, so I need to drop off and pick up. It's
what is drop off and pickup time?
7:30. Up this 30.
All right, you want to ask number 1? Number 1 knows drop off and pickup time. I'm sorry, number 2. Number 2 knows drop off and pickup time. When's your pickup time?
Oh, sorry, yeah, 7:30 is the drop off and 2:30 is.
All right, thank you. Number 15,
Then Friday, I took my son, 7:30 and 3.
1:30. And what time is the medical appointment? 21.
I have 6 dogs at home that are unsupervised right now.
Good luck with that.
Yeah.
Number 37. I need you to stand, please.
I have all day training that's scheduled on the 5th.
And what does the training entail?
It is a sales and service intensive training class.
Okay. All right, thank you. Number 41.
It's actually a day, Wednesday, I have a funeral and a committal at Fort Sam.
All right, thank you. Number 42.
This counts as my birthday tomorrow.
Happy birthday month. Thank you. Are there any plans for tomorrow? What time?
Probably breakfast and.
Okay. We'll try to make sure we have some breakfast here for you. If you're here, we shall see. Number 45.
I'm the only one that runs.
All right, and who's taking care of that now? Okay, all right, thank you. 48,
I've helped train new employees first, or I'm like open up the rest of the.
all right, thank you. Number 50,
I'm currently scheduled to fly to Colorado Springs on work travel this week.
when are you scheduled to fly there?
The Wednesday, I think our flight's like around 5 p.m. or so. It's late after.
All right. Number 52,
The medical appointment on Thursday,
what time?
3 o'clock.
Thank you. Number 55,
Yes, I started a position in Corpus, got promoted. I was supposed to be doing today.
so do you live in Corpus?
Now I'm transferring over.
Okay.
I have an apartment.
I'm sorry, what?
I have an apartment that I'm renting over there currently.
All right, thank you. Number 57,
I have a medical appointment Wednesday at 8:30.
all right, and then number 10, do you have jury trials?
No, Your Honor. No jury trials, just regular hearings. I do have a medical appointment at 8 a.m. Thursday, but that'll be quick.
All right, thank you. Number 12,
Oh, I live with my boyfriend. He has the legal custody of his 6-year-old. He doesn't have family here. I pick her at school every day at 3:30.
all right,
You don't have any, I know the guardian or anything, but I live with her. I have to help her with the homework,
okay. All right, thank you for letting us know.
I have a question.
Yes, what is your number? What is your number?
Sir,
Yes, what is your question?
just a question. I'm working at Tracy County and I have my schedule for, I believe the rest of the week.
Mhm.
If I have to be here, you give me a letter or something
Yeah.
for them? Okay.
Yes, thank you. Yes,
Question. I was denied.
and your number 18.
18. I take care of my 2-year-old granddaughter. My daughter works, so I take her from 7 in the morning till about 5 in the afternoon. But I was told that I couldn't claim that. So is that correct?
Mhm. Well, we will see.
Okay.
All right, so here,
Because I filled that in and I got the denial.
all right, so see, now we're,
Okay, so since they were saying figured I'd ask.
Okay. now we're at the point where people see that nothing happened to anybody for raising their card. Now everybody wants to raise their card. So 24.
I was denied.
No, not you, 24.
Oh,
Just give me one moment. 35.
Ma'am, there's a Friday time that was, mentioned. It would conclude by which time? Could someone rephrase that? Because I realize I have a medical thing right now.
All right, what time is your medical on Friday?
Dental procedure at 2 o'clock.
All right. All right, thank you. All right, so everyone, we're going to take a short break. This is what I need you to do. Look to your left, look to your right. You're responsible for that person being back in line. So everyone, before you start running for the exits, 1, you need to leave your numbers behind. 2, I'm going to want you back here by 3:55. Does everyone understand?
Yes.
All right, everyone, please rise for the jurors.
After a defendant chooses to stand alone in a serious felony trial, the next case shifts the pressure to sentencing. This time, Judge Boyd is looking at a man who says he changed after prison. But the facts before the court involve an elderly person, a glass bottle, and a plea agreement with prison time still on the table. The question is whether his explanation can survive Judge Boyd's scrutiny.
Court is calling 2025 CR 009869 State versus Fidencio Gonzalez. Can I have parties announced?
See,
Okay, it's not as I think we have one list.
And are you Mr. Gonzalez? You entered a plea to count 2. According to your plea bargain agreement, punishment is to be assessed at a cap of 10 years in the prison. There's a $2,000 fine. The state is opposed to your application, and they're taking in consideration 2025 CR 012507. Let me see. Was the PSI waived in this case?
No, you're okay.
All right. Have both parties had a chance to review the PSI report? Any objections, defense?
No, you're.
All right, state, do you have any witnesses?
No, Your Honor.
Defense, do you have witnesses?
You have one.
All right, call your witness.
Hello, here.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Make sure you keep your voice up so everyone can hear your testimony. If you'll state your name for the record. All right, you may proceed.
Ms. Gonzalez, you are married to the Enzo Gonzalez, is that correct? And you understand that the day of the judge's decision on this application for probation, that's all. I understand that you want to address the court at 5 different. Is that correct? But what is it that you want to do before?
This is mine. It has been kind of hard, but I still put, you know, this is a good office.
The pre-sentence investigation report indicates that you have certain conditions. What is your? And how does that affect you? How often do you have these installed? It's a regular weekly occurrence, right? So when you're unable to get out of things, who is it that assists you around the house with your son? What kind of things does he do? Is that important to maintain the household? Do you have anybody else that step in and take that role? You understand that this has some problems with. You think if you offered it. Assistant in way you could. Good means driving into it. And you think that he's in a position to be successful? You and he have had opportunity to discuss this case over for last week. Has he indicated what's going about what happened? You could go back and change. You were present this once there was just a whole lot of decisions. Pretty much set up.
Too bad, man.
The week that
All right, before you cross off the record for a moment. Okay. Okay, now I remember. All right, you may proceed.
Well, you would have standing. The first thing you gotta get on.
We're married on the like conference. We see because is your son playing around with yes, yes. Would it surprise you to learn he pulled the PSI officer that you're signing? So what Mr. Gonzalez told the PSI officer. Does Mr. Gonzalez have any dependents? What do you think that someone can do on both of them so they're asking?
All right, any other questions? All right, thank you for coming in. Any other witnesses?
You understood.
All right, you can come forward. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. All right, you may proceed.
And it's for you.
I don't think remorse is never. The right word is they go the way down last weeks. But I'm being understand what for they said about the jump. Still be I don't see. I don't know. You work out for my Bible.
You got the tape? Oh.
I really wish I
Did she do it? She
did.
did.
But I remember texting back and forth with her once in times because her phone was actually when I was they have to expensive. All I do is
Okay, so here's the thing. This is what I don't understand, and I want to get to the crux of the issues. I don't understand how you say you've been to prison, you learned from that, and now we're here with somebody being hit over their head with a bottle, and it's an elderly person.
Right.
So explain.
You just think about a couple of things.
I was just,
You really
honestly, I was just trying to. Communication is key.
Which is the- But you're not liable.
There wasn't line.
It's the same thing.
I know it's. Been 10 years.
Big picture.
I'm not trying to use it, but I haven't.
No, it's just-
Next time. So I know that. But I know that.
But in the police report, you know what it says? In the police report, it says that this person was trying to stop a fight and he ends up getting hit in the head with a glass bottle. No, I mean, I'm reading, this is what it says.
And I don't know if the court recalled that she viewed the video.
Yes, I did.
In that video, what you'll see is the complaining witness goes outside a door to where the NCO and his family are. He then comes inside and he's just standing at a table, and then there's a rush to go run over there. He's not involved in separating it from something. So I think there was a full-on stuff going on that day, and there was a separate incident going on.
Oh, now I know there's a separate incident. I remember this. There's a separate incident. There's a shooting involved and there's all of this other thing that's going on. I understand.
When
And she'd say, bring it up to me.
Fidencio wants,
Right?
for the Cruz.
Not with Abel.
He's not, the Cruz is not in, you know, separating or stopping, but the video shows of pulling the Cruz back into something, what he's initially trying to go out.
Oh, I'm sorry, it's Della Certa. Yes. Okay. You may continue if you have something else you want me to know.
There's problems. Subscribe for what it might, I apologize.
They never paid you the
Yeah, it's 3 times.
Does that help you?
Okay. I was really,
Actually, hurt.
I mean, that's enough. Do what I've been trying to do. My family.
Well, see, here's the thing. People always say their family needs them, but they don't think about that beforehand.
That kind of, I'm not trying to go into everything. Was about that type of language shouldn't have happened. I'm do everything to figure out, anything that ever happened, like off camera where nobody has seen. I'm the one always trying to know I'm walking away from that. Very unfortunate and different. That's never happened.
Right.
State any questions?
Mr. Gonzalez, you would agree that you've been on probation. Well, in 2007, you were on probation for a theft, is that correct?
Part of it is. It's a question.
You can't recall. Okay, would it surprise you to learn that you were put on deferred adjudication and that probation was later revoked? You can't remember?
I'll get up and say.
Was that juvenile? I've grown up a lot. I've grown up a lot. I was 16, 17, I was just one.
And then in 2009, how was it open? Okay, and you recall the conviction in the
Yes, I was there, but I was in prison already.
Okay, and then again in 2007, you were sentenced, is that correct?
That was for all the same thing, the same
This-
time.
Do you recall what offense it was though on 12/3/2007? The aggravated robbery, yes. And you were sentenced, correct?
That's one.
So how can you reconcile to this court that you were changed if it was only 4 years between that parole discharge and the new one?
Or discharge?
Mhm.
Well, from the moment that it happened, yeah. And I know that from the time that the discharge, there's some things. You're right, I went into prison, I was 19, and I was a kid still. And whatever that I went through, I grew up, and I'm not that same person anymore. I'm a adult, and I understand everything that's going on, and that's why I try to stay away from the problems. I'm just trying to just build my life and build a family, and that's it. I don't never want to be in this courtroom. I never imagined myself being here again ever in my life. It makes me sick.
If you are here again, correct?
Yes, ma'am.
No further questions, right?
All right, any other witnesses? All right, the court will hear argument. State.
Your Honor, we'd be asking for you to sentence for 10 years, and deny the defendant's application. He's already taken a trip to TDC for a violent offense. It was paroled 4 years prior to the same offense, so because of his history, and then he chose the underlying offense.
Defense.
Your Honor, the aggravated offense that he had occurred in 2007. He was 19 years old. He spent a large amount of time locked up and on parole. He successfully charged with parole. He was revoked. So he did well on parole and did well for the 4 years in parole this case happened. As the court knows, it was a lot of things going on at that bar. It was tragic. It affected Mr. Gonzalez and his wife. Honestly, so he's changed from the if he was in prison. That's inaccurate. It's true. This particular night though, things got out of control and all the way around. And made a bad decision. I understand that the court's in a difficult position, and making good decisions, if they feel comfortable that you're letting the court know that he's been reliable, he's been trustworthy, he's done what he said he's supposed to do while he's been on this monitor lately. We would ask the court to take a chance on him. He's not in the future, the court that he can in fact succeed. If he screws up, then but I don't believe that's gonna happen. He and his family will position successful.
All right, this is what I'm going to do. I'm gonna have you come back here tomorrow at 9. Attorney, you need to be here exactly at 9. And at that time, I'll give you my decision. All right. Thank you. Ms. Ferguson, if you can give them a reset form for 9. Thank you.
These two cases show two very different sides of Judge Boyd's courtroom. In one, a defendant insists on representing himself while facing charges that could expose him to decades in prison. In the other, a man asks the court to believe he has changed, while Judge Boyd focuses on the actual harm described in the case. The common thread is accountability. Judge Boyd does not rush past the details. She slows the courtroom down, asks the questions that matter, and makes the consequences clear. Comment below with which moment stood out most to you, and subscribe to Court Beacon TV for more real Texas courtroom breakdowns. Every ruling has a reason.